Thank you, Mr. Speaker. As has been said by previous speakers on behalf of the Labour Party, we will be supporting this bill. Sir, I concur with some of the comments that have been made by both of the last two speakers. I agree that we have some imperfections in our justice system. It does, I agree with Mr. Quinn, take far too long on average between arrest and trial in criminal matters. We need to improve processes there, and there are a lot of things that need to be done there to reduce the complexity of trials and to make sure that people get a fair trial, but that it is not too late after the offence, partly because people languish at the cost of the state, often in prison if they haven't got bail, during the period between arrest and trial, and that's both unfair to them on occasions and also a waste of taxpayers' resources. I also agree that in respect of civil litigation has become so complex and costly that most litigants now can't afford to go to the courts to resolve their disputes, and given that one of the reasons that we have courts is to give a mechanism for people to have those disputes resolved, means like standover tactics or violent disagreements, then there's something wrong in our system. This bill actually does make some good changes. It says that in respect of audiovisual technology that it can be used on some occasions, and then it sets out some rules around that, and I think that I would like to refer to some of those rules. It says that, well, for things where there's no evidence being given in a criminal trial, well, the presumption ought to be that the matter can proceed by way of audio-visual links. So these are things like a bail application or a call-over. Something might have been originally presented in court on one day and then adjourned to a day a month later, and everyone's agreed that at that month later date it's just going to be referred to a subsequent date for a plea of guilty or for a trial. Now, that call-over, there's really no point in going to the trouble and expense of necessarily having all of the parties present, and so where there is no substantive evidence being given and there's no substantive question being tried by the court, then it's perfectly proper that video technology be used on some occasions, and indeed that there should be a presumption in favour of its use. That presumption can, of course, be overcome if there are good reasons not to use audiovisual technology in a particular instance. In respect of civil matters, again, the test doesn't need to be as high as it does need to be in respect of a criminal trial where the substantive charge is being heard. And so there is a relatively there's a lighter test in respect of the use of this new technology in civil matters than applies to matters where the substantive criminal charge is being heard, such as a defended hearing or a jury trial where someone is charged with a crime. However, in respect of the substantive trial, then it is proper that there is no presumption in favour of use of this technology, because there is a lot in what Honeharu said, that we ought to give people the opportunity to hear and be heard if they are on trial. The definition in this bill of who this new law applies to is a wide definition, and it refers to any participant in a proceeding. And a participant in a proceeding can include a defendant or a party to a trial. So I would not like to see a system where we were forcing the defendant into a trial process where he or she didn't have a right to be there personally. Legislation by setting out criteria when and when not to allow the use of audio-visual links, and those criteria are set out firstly at clause 5 of the bill, and then in respect of criminal proceedings additional criteria are set out at clause 6 of the bill. And one of those in criminal proceedings, the overall consideration is the impact or the potential impact of the use of the technology on the right of the defendant to a fair trial. So that is at the heart of when this can be used in criminal proceedings. There is one area that I do disagree with one of the speeches that was given by an earlier speaker on behalf of National, and that was the contribution that Simon Bridges made. Simon Bridges said that he agreed with the use of this technology, but then went on to say that he could see it being extended in respect of the substantive trial in a criminal matter. And he said that, and I agree with him, that demeanour doesn't prove truth. Someone can present as a fidgety witness who looks nervous, and a lot of people are understandably nervous when they are in court, even as a witness, and that fidgetiness or nervousness does not necessarily indicate that the person is lying. Similarly, someone might appear at a trial and have a very calm demeanour, but that calm demeanour doesn't prove that they're telling the truth. Stated. But where I disagree with him is taking it to the step further and say that suggests that we can rely more on audio-visual language where you don't have the same access to body languages and the nuance of someone when they're giving evidence, because whilst demeanour doesn't prove truth or untruth, it's certainly relevant to the assessment of whether there is truth or untruth. And whilst demeanour won't always show to a judge or jury as to whether someone is lying or is to be believed, on occasions it does. And the defendant ought to have the ability to have recourse to those occasions, and the judge or jury ought to see those occasions. There are many occasions where a witness isn't fidgety or looking nervous in respect of the whole of their evidence, but when they come to the crucial part of the evidence which is being contested and where there may be an untruth being told or a gilding of the lily in one way or another, their body language changes. And in respect of that sort of situation, it's very important that the witness is there to be seen by everyone, by the jury, by the judge. The defendant gets the sense that his or her trial is fair. And we only need to think of our own experience in this House when we have audio-visual presentations from people at Select Committee. Although, again, that's a great facility that saves cost to people, on occasions I do think that you lose the passion of and the sincerity of a presentation compared with that which you see when the person appears in person in front of the Select Committee. So whilst the Labour Party supports this legislation, we do emphasise that we do so on the basis of the protections that are found in the legislation, which have different presumptions in respect of different sorts of processes, so that for a criminal substantive matter where evidence has been called, there is no presumption in favour of the use of this technology, because in many occasions in a substantive hearing the evidence will be inappropriate to be heard that way. Now, having said that, you can't ban it being used in all criminal substantive matters, because there will be occasions when all parties, including the defendant, agree that it's appropriate that that matter be traversed by way of audio-visual evidence. And an example of that might be where there is some professional evidence being given about some theory of a pathologist as to how somebody died, or or an alternative cause of death being postured, and the witness that has that specialist expertise could be overseas, could be in everyone's interest, the Crown, because the Crown wants to get to the truth of the matter, the defendant, because the defendant wants to prove his or her innocence, that the evidence of that international expert in this narrow little field be available to the court, and in practice that may only be affordable to the defendant through the use of audiovisual technology. And it could be very appropriate that that be allowed. This legislation would allow it without creating a presumption that audiovisual evidence could be forced upon a defendant where the demeanour or the truth of the truth-telling of the witness is one of the matters that is at issue, and where that person ought not to be forced to give evidence. So for those reasons, the Labour Party will be supporting this bill to Select Committee. We think it is an appropriate advance. It won't make much difference to the cost effectiveness of trials, but it will make a small difference, and it's a step in the right direction. Thank you.